You decide to go to doctor number 2 to continue your medical care and treatment. You get copies of your medical records from your first doctor and bring it to your second doctor. But now, about 6 months later, you realize that the injuries you have are because the first doctor was careless and caused you all these harms and injuries. And now, your attorney tries to get copies of the medical records from doctor number 1. But guess what? Doctor number 1 says, I don't have the records. I can't find the records. Can you use the copies that you obtained originally from doctor number 1 as original records? Can you do that during the course of your case? Come join me for a moment as I share with you a very interesting prospect. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This happens more often than you think. So now here's the scenario. You were being treated by doctor number 1, the doctor whom you loved and trusted for a long, long time. And now, apparently he did something wrong, or at least you feel that he did something wrong, causing you significant harm and injury. And now you decide, you know what, I'm going to another doctor. I can't continue to be treated by this doctor whom I believe caused all these harms and injuries. Okay, doctor number 2 says, what did the first doctor do? Do you have copies of his records? And you say, no, but I'll go get them. So now you go to doctor number 1's office, you ask for copies of the records, they give you the copies, and you take them to doctor number 2. Okay, so now doctor number 2 reads through them, and he makes a comment, says, you know, I think something was done wrong here. That puts a little thought in your mind that, hey, maybe the problems you're having are really because the first doctor violated the basic standards of medical care, causing you these injuries. Now you find an attorney who you believe is the best lawyer for you, and the first thing your lawyer has to do is try and obtain all of your medical records. Then he has to take those medical records and have them reviewed by a medical expert or one of your treating doctors, who now has to review them and confirm that, yes, number 1, there were violations from the standard of care. Number 2, that those violations, the improper medical care, that carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And that, yes, your injuries are significant or permanent. So now, when your attorney requests your doctor's records, he gets a response back saying, we can't locate them. And your attorney says, what do you mean you can't locate them? You are obligated by law to maintain this patient's medical records for a period of years. Where are they? Did they just disappear magically? Who signed them out last? Who had them last? Who made an entry in the last chart? And now he's waiting for answers. And it turns out they can't explain why these records are missing. They don't know why the records are missing. But you tell your attorney, hey, listen, the office gave me a copy of my records and I brought them to doctor number 2. Okay, so now your attorney requests records from doctor number 2. Now, interestingly, doctor number 2 only provides copies of his own records, not copies that you brought to him. And you call up doctor number 2 and say, hey, doc, I brought you all the records from doctor number 1. He says, yes, you did. And now he has to try and find them. His office can't find them either. This is the case of the disappearing medical records, as if the doctors are writing them in disappearing ink. No, that's not really what happened. So, here's the scenario. So doctor number 2 has copies of the original records. They just misplaced them temporarily. And now, ultimately, they do find them. Okay, so now your attorney is able to get copies of those. So what happens at the time of trial? Now, 2 or 3 years down the road. And why do I say 2 or 3 years down the road? Because that's how long it takes for these medical malpractice cases to get to trial. You see, what you may not know is that when you sued your doctor, doctor number 1, he and his attorney turn around and says, why are you suing me? I did nothing wrong here. And if I did something wrong, so did you, Mr. Patient. And then he says, you know what? If I did something wrong, whatever I did didn't cause or contribute to your injuries. And then he says, you know what? Even if I did something wrong and you did something wrong and whatever I did cause your injuries, your injuries really are not that bad. Those are the typical defenses that we see in these medical malpractice cases. So what that means is that they're never going to negotiate. They are never going to try and settle this case before trial. Okay? That means your case will go the distance, 2 to 3 years down the road. But what does this mean if your attorney cannot get the original records into court? Because you should know that as your case gets closer to trial, your lawyer has to actually prepare the case. He has to send out subpoenas to make sure that your medical records arrive in court. And he has to do that by showing a chain of custody. And that's a topic for another video, but the bottom line is, your attorney has to request that your doctors and the hospital staff provide copies of your medical records. Importantly, I should say provide certified copies of the records. Because, here's the interesting thing, the hospital and the doctors don't have to provide the original record. Instead, they have to have a record keeper, somebody who works at the hospital or somebody in the doctor's office, say, yes, this is an exact copy, an exact duplicate of your original records. I hereby certify that these records are accurate and complete. And now they sign it, and they attach that to the documents, to the medical records, with the subpoena, and they send it into the medical records department in the courthouse. And there it sits until your case gets called for trial. Then, when your case gets called for trial, guess what? The attorneys go into court. One of the first things they do is they go down to the subpoenaed record room, the medical records where they're kept. And now we go through to make sure all the records that we serve subpoenas on, all the doctors and the hospitals that we ask for your medical records, that all of those things are there in court ready to go. Because we need that to introduce into evidence to show that you are more likely right than wrong. And all of the witnesses, all of the medical witnesses who will be testifying will need those records in order to give their testimony. So let's go back to the question I raised at the beginning of this video. Let's say that doctor number one, for whatever reason, can't find your original records anymore. And now they can't explain why they don't have those records, nor do they have a copy of the records in their file anymore. That's a significant problem. But lucky for you, you had actually obtained a copy of those records and brought them to doctor number two. And doctor number two finally found those records and gave a copy to you. So now your attorney has to go through a little bit of hoops in order to get doctor number two to confirm and certify that the records that were provided to him were the actual records, or at least copies of the records provided to him. Now, by doing that, because they are copies and the chain of custody appears to be somewhat choppy, the defense lawyer is certainly going to attack the credibility of these particular records. Number one, he's going to argue, where did they come from? Number two, he's also going to argue, how do we know that these are complete and accurate? And then he's going to say, how do we know that the injured patient or someone along the way didn't take out certain pages? We have no way of knowing that. And you know what? Those are all valid arguments. Those arguments will be made during cross-examination of various witnesses. Oh, here's an example. Let's say we have our medical expert on the witness stand who's now talking about the violations from doctor number one, that he departed from good care. So now, the defense attorney gets up to cross-examine our medical expert. And one of the first things he's going to attack him on is whether or not the records that he reviewed are complete. Doctor, the records that you were provided, those copies of doctor number one's records, do you have any personal knowledge about whether that's the complete file for this patient? Well, no, I don't. Well, how were you handed those records? How were you given those records? Oh, Mr. Oginski mailed them to me. All right, do you know where Mr. Oginski got them from? Yes, from doctor number two. Okay, how did doctor number two get them? Well, my understanding is that the patient brought them from doctor number one to doctor number two. Well, doctor, do you know for a fact that the patient didn't remove any records before bringing them to doctor number two? Well, no, I don't have any personal knowledge of that. Doctor, do you know whether or not anybody in doctor two's office removed any documents or added documents? Well, no, I don't have any particular knowledge of that. So again, the whole purpose of this is to show that those medical records are going to be attacked on the credibility and authenticity. So if the original records are unavailable, but we do have copies, yes, we can use those copies as long as we can show that there is some chain of custody, and as long as we can show they are, hopefully, full and fair and accurate copies of what should have been original records, and the original records can no longer be accounted for. In that instance, I believe those records will be allowed to be introduced into evidence, subject to the defense being able to cross-examine various witnesses about the authenticity and the completeness and accuracy of those records. So why do I share this great information with you? I share this with you because this does happen from time to time, where a doctor's office or hospital staff says, you know what, we can't locate the original records, but we know somebody along the way got a copy of them. So let's use those. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need answers. What I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.